Hey, what is going on, crypto people? This federal judge court ruling is, in my opinion, going to be the downfall of the SEC in any future enforcement actions or anything that any federal regulator brings to a court. I really do believe this. This is a 51 page uh, ruling from the judge, the Honorable Judge Michael Wiles, federal court judge, who literally just, we covered this before. Look, and I said to you guys, look, when the Honorable Judge Torres mentioned, was it Netflix or Torres, whichever one it was, who said that the SEC is acting in a manner that is an unfaithful or lacks a faithful allegiance to the law. And we said on this channel, what do we say? We said that those words, and I know it's a part of that I'm missing. Let me know in the comments if you know the other part that I'm missing, right? But I said that those words were going to echo throughout the judicial system, every attorney, every other courthouse, right? It was going to, even up to the SCOTUS, was going to echo throughout the judicial system, right? Because there isn't going to be a judge or court that is going to put up with the nonsense and the shenanigans. They're not going to want that to come to them in their courthouse. They're not going to put up with it. And this judge, we covered this in a couple of videos, how he went and he laid in on the SEC attorneys. Now, I'm going to go through this ruling. And it's interesting to me that this ruling was about the Voyager case and the objection by the SEC in that Chapter 7 bankruptcy. The objection from the SEC and the Texas state regulators, the U.S. trustee has some objections as well, but it was just hearings about Binance being able to acquire the assets from the Voyager customers. And the objections by the SEC really, not by the U.S. trustee, not by the Texas state regulator, but by the SEC, really struck a nerve with the federal judge. He was like, what are you talking about? And why are you talking about this nonsense in my court? Okay, I'm going to go over the rule. This is the official ruling. It's done. Binance, check mark, won. Okay, now I don't know if the Voyager customers are happy or not, but I really want to talk about, and by the way, March Madness, baby. March Madness, baby. I want to talk about the ruling. And the things that the judge is bringing, and what he does is he addresses the objections, because this is the ruling, this is it, done, over. And he addresses the objections one by one. And guess who he started with? That's right, the United States SEC. So I'm going to get into it. Forgive me for reading because I don't have it down pat, but I wanted to share this with you guys because I'm telling you, this is massively important. And again, why this ruling is so important, just think about it for a second. Jimmy James case filing, just let us know that Ripple used a Supreme Court judge's ruling, is using that ruling for their fair notice defense. Let me share over here. Ripple files a letter regarding recent Supreme Court case that supports Ripple's fair notice defense. Now, here's the more important part. This opinion strongly supports the defendant's fair notice defense, listen to this, because the government's prior guidance appears to contradict its present litigating position. This is what Judge Torres said. Judge Torres, on that, whichever one it was, kept saying, you come in on Monday and you say A, and then you come in next week on Monday and you say B, and then you show up the following Tuesday and you say C. This is what she essentially said. And this is exactly what's going on in other courts. This happened to be a Supreme Court, and Ripple is using it for their fair notice defense. But it's not, what the world? It's not that it's about the fair notice defense, because in addition to that, it's highlighting the contradictions, it's highlighting the shenanigans that's going on at the SEC. So here's Judge Wiles. Let me say at the outset, and as background to my rulings, important. Let me say at the outset, and as background to my rulings, that I cannot think of another case I have had that comes before me in a setting quite like this one does. And by the way, side note, this judge was aware and on every single, this dude was aware of FTX, Celsius, Alameda, everything, 3 Hours Capital, Luna. This dude referenced every single thing that's going on. Woo, sharp, sharp. I'm aware that there are some people who question the very concepts. I'm not going to say cryptocurrencies. I'm going to say digital assets. He used cryptocurrencies. I'm aware that there are some people who question the very concept of digital assets and the whole idea of digital asset investment and trading. I know that no party in this case has taken such a position, and it is not for me to decide whether particular investments are good ideas or not. But it certainly provides an unusual backdrop in this or to this bankruptcy case. I am also aware that Voyager operated and Binance US currently operates this is very important, in a regulatory environment that at best can be described as highly uncertain. Bam, we'll listen to these words again from the judge. I am also aware that Voyager operated and Binance US currently operates in a regulatory environment that at best can be described as highly uncertain. Like, I don't even need to read. I don't even need to read anymore than that. These are firms that operate as cryptocurrency brokers or exchanges and have done so for several years. Without being subject, this is important, without being subject to clear and well-defined regulatory requirements. Again, this gets put in the courts. This is the final ruling. And you're suggesting to me that other attorneys and other courts are not going to be familiar and use this as reference in their decisions on the win or on the L? You're telling me they're not going to use this stuff? Of course they are. Listen to this. Regulators themselves cannot seem to agree as to whether digital assets are commodities that might be subject to regulation by the CFTC, or whether they are securities that are subject to securities laws, or neither, or even on what criteria should be applied in making the decision. Do you see what I'm saying here, guys? Like, to me, it's over. Now, the SEC can stack up all they want and ask for all kind of money all they can do all of that. Cool. But this is law. This is judges again and courts again and attorneys again are going to use this because this is unprecedented stuff. That's why he said let me say at the outset in the background to my rulings that I cannot think of another case I have had that comes before me in a setting quite like this one does. If the current regulatory environment can be characterized as uncertain, the future regulatory environment can only be characterized, in my mind, as virtually unknowable. Ooh. Do you think, let me ask you something. You guys know the Fed now, the Faster Payments Council, whatever, whoever announced it, Fed now is going to be active in July. Don't you find it odd that this announcement just comes right on the heel of this ruling? Do you think that's odd? Do you think that people are sitting back waiting for what they believe is going to be a favorable ruling for people who might be participating? It doesn't matter, and or their partners people who might be participating like Ripple and or their partners on this FedNow service that's going to provide instant payment settlement, instant, and it's going to be operating 24/7, 365. You think it's a coincidence that Ripple years ago, or about a year and a half, 2 years ago, said that they were a blockchain infrastructure company? A blockchain infrastructure company, which is what modern payment system of FedNow is, because of people working on the infrastructure. Now we could talk other digital assets. We could talk. It don't matter, in my opinion. But you think it's a coincidence? They announced this. I don't. I think that the appropriate people, certain people, are waiting for this case, the SEC versus Ripple case, to be done, so that they can move forward. Again, doesn't mean that it's Ripple, doesn't mean that it's XRP. It probably is not. But what it does mean is they're waiting for rulings from the judges for a reason. For a reason. Anyway, so here we go. Can be, in my mind, can be characterized in my mind as virtually unknowable. There have been different proposals in Congress. This dude is on it. There have been different proposals in Congress to adopt different types of regulatory regimes for cryptocurrency trading. Meanwhile, the SEC has filed some actions against particular firms with regard to particular digital assets, and those actions suggest that a wider regulatory assault may be forthcoming. Listen to me, this dude is saying that he understands the environment that the digital asset space is in. He understands what is likely on the horizon. And so he is saying, in my mind, he is saying, I'm making a ruling that I think is significantly important for the future of this space. To me, that's what he's saying. The CFTC seems to have taken some positions that are at odds with the SEC's view. Just how this will all sort itself out, how the pending actions related to digital assets will be decided, and just what issues might be raised in future regulatory actions, and how they will affect individual firms or the industry as a whole is unknown. Complicating things further is the fact that Voyager operated and Binance US continues to operate in an industry that has also been the subject of severe financial shocks over the past year. Telling dude is on it. I mean, respect, as we like to say, respect to Judge Biles. Many firms were adversely affected by the loan defaults of 3 hours, including Voyager itself. The 3 hours defaults led to several bankruptcy filings across the country. The more recent and sudden collapse of FTX has reverberated even more throughout the industry and has also led to some financial problems at other firms. Perhaps the most worrisome for me are revelations of apparent misbehavior and misuse of customers' assets at some firms. Again, the judge is on it. And this is my whole point. That's why they said in the live stream before, they are on it. They are paying attention to the environment that this new asset class is trying to operate in. They're paying attention. I am also aware of the examiner's report about the conduct of business at Celsius. Telling this guy's on it. All of these judges are going to be on it. They understand that they know, just like John Deere knows. We're not getting stuff. We're not getting stuff from Congress. We're not getting clarity and rules of the road from Congress. These judges know that it is upon them. The impetus is on them. They know it. I mean, this dude is on everything here. He says, but the examiner's report certainly raised the prospect of a disparity between the way that particular firm, we could use this in the Celsius case. Well, Judge Glenn can use this in the Celsius case. He can go over this and think about this, take this in consideration as well. It says, but the examiner's report certainly raised the prospect of a disparity between the way that particular firm, Celsius, actually operated and the representations it made to its customers. Hey, we can use this. The Celsius, you mean the loans ad hoc group can use this. Mr. Adler can use this. Disparity between the way that the particular firm actually operated and the representation it made to its customers. He used the word disparity between the way that particular firm actually operated and the representations it made to its customers about how assets were handled. In this particular case, some account holders and some of the parties have referred me to newspapers or magazine articles, or to a recent letter by a group of US senators, all raising questions about how Binance US does business, and perhaps more questions about how its affiliated companies, Binance, do business. Despite the questions that have been raised, however, I must note, now remember, US trustee, you got a UCC, you got law firms for both sides, you got state, federal regulators presenting evidence to this court, and you got federal regulators like the SEC. All these people. This is what he said. Despite the questions that have been raised, however, I must note that I have been offered. Let me say this again. I must note that I have been offered absolutely no actual evidence. And he goes on to say, I mean literally, zero admissible evidence. Do you understand what I'm saying here, Sam? Do you understand what I'm saying here, fam? Are you catching what I'm putting down? That would support an accusation that Binance US is misusing customer assets or is engaged in misbehavior of any kind at all. Instead, I am in the unenviable position of having to make a ruling about the proposed transaction in the face of hearsay accusations of potential wrongdoing in an industry where other firms have apparently engaged in real wrongdoing while having absolutely no evidence indicating that there is any good basis for the questions about Binance US that have been raised. United States trustee, state federal regulators, state federal regulators, and then government regulators like the SEC. These are the people posing the objections. Do you understand what's going on here? Do you think the state regulators, by the way, are taking their lead from someone, or they're just acting on their own? All right, let me see, what else can I share? All right, it says, with those observations to put things into context, let me turn to some of the actual objections that have been filed. The first one that I will address in this objection filed by the Securities and Exchange Commission. The SEC argued in its written objection that the debtors cannot prove the feasibility of the proposed plan for two reasons. First, the SEC argued that in its view, the debtors had the burden to prove that the rebalancing of the debtors' digital asset portfolios in preparation for planned distributions would not involve an illegal purchase and sales of securities. Again, where do you think the SEC, it's always about the securities thing. The objection, says the judge, did not take the position that any particular digital asset are securities. The objection did not take the position that any particular digital assets are securities, or otherwise explained how or why the debtors rebalancing acts might be illegal, although it did contain a vague footnote suggesting that the BGS token was one as to which some specified issues might exist. Do you see what I'm saying? He is calling out. The dude is calling out the SEC's plan. He's putting judges and further courts on notice that we are hip to your plan and that you're coming before us. You're coming before our courts, wasting taxpayer dollars with nonsense. He used the word hearsay accusations and potential wrongdoing without bringing actual evidence. He said literally zero admissible evidence. And I'm telling you, fam, this judge has sounded the alarm that this court in the judicial system is hip to your game, SEC federal right. I'm telling you, on notice. He's putting them on notice. My opinion. The SEC also suggested that the debtor should be required to prove that Binance US is not operating as a security broker without registering as such. Listen to these words. Listen to these words, guys. It's so important. Once again, the SEC did not actually take the position that Binance US is operating as an unregistered and unlicensed securities broker. Just like with the BGS token. They're not saying it's a security. They're noting that it could be, or it might be, or perhaps one day it could, all of this nonsense. And he's saying they're doing the same thing about how Binance is operating as an entity. Instead, let me say this, instead it just suggested that the debtors had the burden to prove the negative without offering any evidence or even any reason to think that Binance US is actually doing anything for which it requires further SEC registrations. And I think it's so important that this is Binance US, massively important. I questioned the SEC about these objections at the outset of this hearing, and to some extent, I rebuked the SEC attorneys for their vagueness of their submissions. Listen to this. This is so important. Again, I'm telling you, sound the alarm that the judicial system is hip to the game that these regulators, in particular the SEC, is trying to put. Let me say it again. And to some extent, I rebuke the SEC's attorney for the vagueness of the submission. Though in fairness to SEC attorneys, I think they were just the messengers and not the architects of the message that they were sent to deliver to me. In my opinion, it's over. Because every judge and every courthouse is hip to the game. This is about as damaging of a statement that anyone can imagine the thought he's saying. Imagine what he's saying here. In fairness to the SEC attorneys who got a boss and they have a gig to perform, in fairness to these attorneys, I think that they were just the messengers and not the architects of the message that they were sent to deliver to me. Here's another one of these faithful allegiances to the law statements. Let me see what else I want to read. The SEC had not even affirmatively contended that the debtors were doing anything wrong or that Binance US was doing anything wrong, nor had the SEC offered any guidance at all as to just what it was that the debtors allegedly were supposed to prove on these issues, or how the debtors possibly could prove that the SEC wanted them to prove without receiving any explanation at all from the SEC as to just why the debtor's operation or Binance US operations might raise legal issues. Judge Netburn, Judge Torres, whoever said it, the SEC, and she's talking about the attorney, but she understands, just like Judge Wiles, that these attorneys are just the messengers. The SEC lacks a faithful allegiance to the law. Embarrassing. The SEC initially asked if I could state, the SEC initially asked if it could state its position only to me on an in-camera basis. But I denied that request and ruled that to the extent the SEC wanted to say something further about its objection, it ought to be stated in the public forum. Why do you think that is? Why does he think the judge ruled that way? Because he's hip to the game that they're trying to play, that the SEC is trying to play. We're gonna make this this whole thing here that he wrote out here was about making it public so that every judge, every other judge, every attorney, everyone looking to defend themselves will have as in record. That's what this is about. Yeah, so the SEC initially, he said, well, he wanted to say something. It ought to be stated in the public forum where all other interested parties could hear and understand the SEC's position. Sounding the alarm that we are hip to your game. And we're not gonna have you come before us in our courthouse, excuse me, wasting taxpayer dollars for your nonsense. As I said then, and I do not know how the debtors could have been expected. As I said then, and I do not know how the debtors could have been expected to be more specific about that question when the SEC attorneys themselves told me they could not answer the question. Listen to this, this is important. The SEC, because they've been trying to make this point about, we believe possibly maybe someday in the future, or maybe one day in the past, that the VGX token was a security. This is what he says. Here, the only issues the SEC has raised are, one, whether one specific token is a security, and whether Binance US needs to be registered as a securities broker. There is no reason why these issues affect feasibility of the kind. The SEC has been aware, massive. The SEC has been aware of the VGS token for some time and has not even reached a conclusion as to whether it is a security, let alone taken any action to stop trading in the token. In addition, even if there are problems with the sale or distribution of VGX, there is no reason to my knowledge why that would or should impede or affect the remainder of the debtors as proposing. This again about this whole objection again was about Binance US being able to take over the assets. And the SEC thought that this could be a little door for them to kind of sneak in their little securities thing that they're trying to do. Exchanges of securities, broker dealers, they need the license, and they're offering security tokens. And he called them out. The SEC has been aware of this token for some time. The VGX token has not even reached a conclusion as to whether this is security, let alone taking any action to stop the freaking trading of the freaking token. Let me know in the comments if you feel like I feel that this judge is sounding the alarm. I told you it was going to be a ripple effect. Once Judge Torres and Netburn, once she said that statement and put it on public record, lacks a faithful allegiance to the law, is over. In my opinion, the plain fact here, says Judge Wiles, the plain fact is, however, that the SEC has not actually made any objection. It has only vaguely hinted at possible issues that have not even been described in a manner that would permit the court or the parties to address them. These are body blows, my friends. Slap downs to the SEC. This is what he says here. This is a court. In the end, I have to make, and he said no, period. This is a court, period. In the end, I have to make decisions based on actual admissible evidence and where legal issues are involved based on cogent legal arguments. I have no actual evidence or cogent legal argument from the SEC or from any other regulator. I told you guys, I've been saying this for a while. There's a war going on. There's a war. There's a war going on. We got to come together, not divide each other. Can't fall hook, line, and sinker for the divine conquer strategy put forth by certain entities of this nation. We got to get it. I have no actual evidence or legal argument from the SEC or any other regulator that could support a contention that the plan will require voyage to the purchase of salary token that should be considered to be a security, or that Binance US is engaged in any activity for which it is required to register as a broker or dealer. This is, I guess, embarrassing, but I love finally we got some judges willing to stand up and speak the truth. I therefore am compelled, sisters, by the evidence and arguments before me to reject and overrule any contention that the transactions contemplated by the plan. That doesn't really matter. In the end, he goes on to say, for similar reasons, I reject the contentions by the SEC and others. Powerful stuff, guys. I could go on and on and on after page after page after page about this ruling and how massive, in my opinion, this ruling is. This, for the foregoing reasons, I will approve the disclosure statement and confirm the debtor's plan of a reorg. And again, guys, I believe this is the end. This is, to me, this is the end of, and not, when I say not in filing, because again, you got a guy who's looking, who has political aspirations at the SEC, right? Who's gonna, and he has people who work for him, and he's gonna send them off court. So it's not like there's gonna be less filings, but the wins, or even the hint of expecting a win, in my opinion, is done. Toast, over. I couldn't be more excited about it because I think Judge Wiles is 1000% correct. And I'm so happy that he called out the obvious. And to me, it started with the Honorable Annalisa Torres or the Honorable Judge Network, whichever one said it, I can't remember. It started there. And thank God, just like John Deaton said, we were so blessed as XRP holders to have those two judges residing over this case. We're absolutely blessed. So guys, there it is. The demise, in my opinion, the demise of future enforcement actions by the SEC has been laid down. The gauntlet has been laid down by not only Judge Torres and Network, but also Judge Wiles as well. Listen, guys, thank you so much for hanging out. It's been a really, really cool hang. What do you think about my new setup? This is kind of, I'm probably going to do this like once a week. What do you think about it? Let me know in the comments if you enjoy this type of stand-up thing. Go check out some March Madness. I hope that your team does well, except when, you know, they come against my boys. I'll talk to you soon, guys. See you. Bye.